Nick, we're going to move on with your question. And this one is also regarding an agent, a tenant and a landlord. What this one specifically says, it's from the tenant, I believe, and the tenant is saying that, oh, it's from the landlord, actually. The landlord said, so the tenant hasn't paid their rent for June, and then it so happens that the hot water in the premises has stopped functioning. Maybe it's a geyser issue, which the landlord would be subject to fixing. So basically, the tenant hasn't paid for June, and now the hot water stopped working, and now the landlord wants to know, is it necessary now for them to actually go fix the hot water, because the tenant is in breach and they haven't paid for June, and it so happens that now the landlord now is also possibly going to be in breach of the contract. Nick?
Perfect. So, yeah, interesting circumstance there. As you say, so the hot water is likely to be a geyser issue within the particular property. I mean, this depends on the property, but it's probably a geyser issue, something that the landlord's going to be responsible for at the end of the day. Okay, they've got to ensure that geyser is working so that the tenant has use and enjoyment. And obviously, in this particular circumstance, tenant hasn't paid rent. The way that the question's framed, I'm assuming that the tenant hasn't decided they're not going to pay rent because of the geyser bursting, and it looks like they didn't pay rent, and then subsequently the geyser's gone off. But you know, these circumstances do happen between landlords, and it can happen in the reverse, where the tenant decides, I'm not paying because the geyser's not working. The circumstances. Now, you know, this is a circumstance that happens to a lot of landlords, and you are going to find your landlords that's in the circumstance where they actually say, look, he's in breach, I'm in breach, we should leave the situation where it is. You know, once they pay, I'll make sure that I get the geyser fixed in the circumstances. You know, some landlords are going to do that. From a legal perspective, which is the perspective we're here to give, it's not a great position. You know, I know a lot of landlords are going to disagree with me. A lot of them are going to say, no, it's what it is. But strictly from a legal perspective, look, as the landlord, you've got to have this fixed. You've got to give use and enjoyment of the particular premises. And when this occurs, you are now in breach of the particular lease agreement. Okay, the tenant can formally give you notice to remedy the breach. Okay, and depending on the terms of your particular contract, they can give you a time period in which to have this problem remedied. Okay, generally that will be 7 days or whatever the case is. Similarly, you as the landlord are in a similar position in that your tenant is also in breach of their lease agreement because they have not paid their rental. And again, you are also in a position where you are going to have to breach your tenants, send them a letter of demand to get them to remedy the breach in that they pay the rental in the circumstances. And depending on whether, what your lease agreement says, if it's on a fixed term, or, do you just want them to pay the rental? Do you want to actually move yourself towards a cancellation, of the lease agreement as a result of the breach? That notice is going to change. And you will have to look at your lease agreement that you've got with the tenant for what period you have to demand for. So the long and the short of the answer is, can the parties now offset their obligations in terms of the lease agreement validity? No, you can't do the offset, but you're both sitting in a situation now where both of you are in breach of the agreement, and you would have to follow due legal procedure by giving a demand to the other party for the remedy to occur. Is that exactly how it works in practice? No, probably not. And that's why I know Bruno was smiling there when I mentioned it, because I know a lot of our landlords will do something different than actually go ahead and give the demand. They'll probably call the tenant and say, listen, sort it out in a different way. And look, although that's not the strict legal way that's required in law, parties must negotiate and settle and deal with their grievances between one another in whatever way they can, without obviously coming in contravention of any act or performing an unfair practice or something that's illegal. Exactly. So look, if the parties go ahead and they sit down and negotiate, the landlord says, look, I'll fix it, you've got to make sure that rental's in, perfectly valid.
Yeah, absolutely.
Yeah. So once again, a nice short and answer that's straight to the point. So yeah, the obligations don't necessarily fall away, but of course, in practice, like you say, things do differ. So yeah, thank you very much, Nick. And I believe that does bring us to the end of today's questions and answers. Thank you, everybody, for joining us once again.
Cool.
Well,
Thanks,
thanks
guys.
so much.
Cheers.